Okay, it is 12:01, so we're gonna go ahead and get started. If you don't know me, I'm Samantha. I'm with the ISBA. With us today, we have Andrea McNeil. Andrea is an attorney down in Marion, Illinois, which is kind of near Carbondale, if you don't really sure. And she is also a member of our Rural Practice Committee. So I'm going to let Andrea take it away.
Thank you. Good afternoon. As she said, I'm Andrea McNeil. I graduated from SIU in Carbondale in 1992, and I've been practicing in a rural area my entire career. I also clerked in Jackson County State's Attorney's Office and at a law firm in Marion while I was in law school. So I'm quite familiar with rural practice. So the topic I picked today, though, is guardian ad litem work. And the reason that came to my mind is when I was first starting out in practice, I was approached to serve as guardian ad litem in juvenile court in Williamson County. And it really did help my overall career, getting that experience. I think I did it for about 8 years, and we'll get into more details of that type of service. But what dawned on me is that a lot of people don't realize that there are many different roles that a guardian ad litem could play. I think most people presume it's some type of family law, but it's not always. And so I uploaded to you just a bunch of different statutory provisions to kind of show you and get you just, I guess, familiar with the idea. A lot of times guardian ad litems are needed in rural counties. Sometimes only one side will have an attorney. And I think the judge appreciates having another viewpoint from an attorney that's not representing either party, but the child, or like in some of the other cases or topics that I have on my list is probate is quite frequent. So probably the best thing, I'm just going to start and go through all the different ways you could serve as a guardian ad litem and then get into more detail on each type of subject. So of course, as I said, the most common is probably family law. And really, because of that, that's why the Supreme Court rules, the 900 rules, were passed. And so I included those in the attachments that were sent to you just so that you could look. Rule 906 is the qualifications to be considered in those type of cases, and how many hours or types of cases that you've done. All of that's laid out, and your CLE and the type of CLEs that you have to continue serving. So all of those type of cases do involve, parental time, parental decision making, any kind of issue that would come up in paternity, divorce, family law type cases. There's also the Adoption Act, which requires a guardian ad litem. I also sent you that section. That's 750 ILCS 50/13. And that lays out where you would have a guardian ad litem represent the minor child in an adoption. So adoptions can be all different ways. I mean, they might involve an agency, it might be related, it might be non-related, where there was some kind of private placement. I've actually had one of those through like a church. The person went to church and knew of the family. So you could also serve in that capacity. And I will tell you this, I had to take this up with my local adoption judge because he kept saying that the GAL had to be on the circuit-wide list, which I'll get to, but that's where you've proved your qualifications, you went through your training, and you're on that certified list that the chief judge keeps. But Adoption Act does not involve parenting, decision-making, parenting time. So those rules do not apply. So I actually had to brief that, and I got my local judge to agree that I could because there were other attorneys that were willing to serve in adoptions, but don't want to be on that list because they don't want to be dragged into family court on those type of cases. So you would need to work with your local judges on that. But you could also serve in adoption cases, which is a really fun area of the law to practice in. It's a happy day in court. And normally, you know, when you get to the finalization, it's one of the few areas where most people are happy when you get the case done. There's also the Probate Act. So you could act as a guardian ad litem in guardianship matters for minors. And that section was 755 ILCS 5/11-10.1. So I sent you that little section in your attachment just to show you when that would come up and that you could be appointed to serve there. So in guardianships of minors, you know, it's not going to involve, a lot of times it's not going to involve parental rights or parental decision making. Only in very limited cases does that even come up. Most of the time it's a grandparent or it's some other family member. The child was just left with them. And so they're trying to get legals to the child so they can make medical decisions and those things. There's also the Juvenile Court Act, which that's how I originally got into it. So that is 705 ILCS 405-2-17. So that's also in your attachment, just to show you that provision that allows for the guardian ad litem to be appointed in the juvenile court matters. And usually you're in it for the long haul. Some of those cases take 2 to 3 years. They're very lengthy, time-consuming type cases. And so a lot of the different counties have part-time, they're called part-time public defender positions for that guardian ad litem position. But a lot of times they also have conflicts because there's so many different attorneys needed in juvenile cases. So you might want to think about getting your name on that list because you could end up appointed for a abused or neglected child in the juvenile court process if you wanted to try to do that. So the type of probate estates, I've had this come up several different ways where in probate court, so see, this is a completely different topic when you're probating an estate. So you've had someone die, you're in court, you're trying to probate the estate, and either one of your heirs or legatees is a minor, and you would need a guardian ad litem to protect their interest, or you have a disabled adult, and the court is going to appoint, in almost all cases, sometimes it's so obvious and there's no one objecting, it's uncontested, they'll go ahead and grant it without a guardian ad litem. But I would say the majority of the cases, there's going to be a guardian ad litem appointed. And so that section was 755 ILCS 11A-10. It's also in your materials. And I actually have a case right now to just give you an example where I was probating a case and I was dealing with the executor's brother. And he was in assisted living, which we knew, but you know, we thought he was fine mentally. And then the facility got involved and wanted to declare that his powers of attorney had been triggered, that he was suffering some mental dementia. So we don't have a doctor's report or anything like that, or no one filed for guardianship of that gentleman. So what I did in the probate, in the decedent's probate case, I motioned for a guardian ad litem because we don't want any kind of conflict coming up. So we had him appointed an attorney to represent his interest in that case. There's also personal injury type cases where the injured person is a minor or a disabled adult even. But I've done these type cases where it was a minor child. And so the court appoints a guardian ad litem to review and approve the settlement of the minor's lawsuit. So in those type of cases, you're reviewing, you know, medical records, police reports, you know, just trying to be sure that what the attorney is recommending and wanting to settle for in that type of case is appropriate and in the best interest of the minor. In your materials, I also included, just to give you an example, the application process that we have in the First Judicial Circuit. And this is, you'll see it says child representative / GAL information sheet. So when they passed the 900 rules a while ago, actually, our chief judge's office put together this form. And so you know, if you want to be considered for that type of work in my circuit, which is in the First Judicial Circuit, then you just fill out this form. And within it, it has the qualifications that you've done 10 hours of approved CLE education in child development, rules of guardian ad litem, child representative, ethics in child custody cases, and the list goes on and on. So a lot of different CLEs would fit that. And then here's the one that I like, because I have twice used this to just be grandfathered in, basically, in my circuit. In lieu of the CLE, you're seeking the qualification based on that you have acted as a guardian ad litem, child representative, or attorney for children. And then you list your 5 cases in the last 2 years and the counsel that was involved in that. So it's a fairly simple form that you just complete. And then let me show you the what they do with that is once the I will get it here in a minute. Okay, here we go. Once the chief judge reviews over that, then if they approve you, this is how our circuit works. Then they'll put your name and your address, your phone number, your email, your hourly rate. We're required to do pro bono. So really, whether you say yes or no on those, you could be selected to do pro bono as well. That's part of the underlying agreement when you get on this list. So what happens is when you need a GAL in our circuit, and in those certain type of cases that are listed in Rule 900's qualifications, you have to be on that particular list. But like I said, you can serve as a GAL in adoptions, you can serve as a GAL in the disabled person type cases without being on that list. That's just a way for you to widen your horizon, basically, of all the different ways you could serve.
And Andrea, could I ask a quick question?
Yeah.
Yeah. So how, if any of the fellows that are on the Zoom are interested in maybe not right away, but once they get a little bit of practice under their belt, interested in becoming a JL, how would they go about getting the training? Because they're not going to qualify for the prior JL experience. So how do they get trained?
Okay, so that list, like an easy way to look at that list is just on that application form that I showed you, and the 10 hours required for the CLEs, like for our circuit to get on that list. It's a wide range of CLEs, and you would just complete 10 hours of that and then fill out the form and submit your information. So I know you guys are from all over Illinois, and my next topic was, how do you get involved in these type of matters, and how do you start getting considered? Well, of course, you're all young, you know, young to the practice. I don't know how old you are or anything like that, but you're young to the practice. So, but you might have life experiences. And so GAL doesn't necessarily have to have a long legal career, but just general life experiences also help in serving in these kind of capacities. And so, and you can easily read the law. Yeah, I always start with that. Like when you're starting a new area that you're going to practice, start by going to the actual statute and read it and then go from there. But so we were talking about how to get qualified, how to get on the list. Well, you're going to want to go to your own circuit rules, okay, your local rules, because we have a set in our local rules about GALs. You're going to read that first, and then overall of the 900 rules, because I attached those, so you can read through those, and the qualification provisions are in there. And then check with your chief judge's office. And so those are all the first steps to start getting considered. And then part of rule practice really is networking and getting to know your local judges, the local attorneys. If there's an area of law that you want to practice as a GAL in, then you're going to want to talk to the bar that practices in that area. So you would want to go to bar meetings and meet attorneys and find out what kind of areas of law they practice in. And if you want to do the personal injury type case, those types and settlements of minor estates and stuff like that, then you're going to want to talk to attorneys that practice in personal injury. So a lot of us that do rural practice, we have a wide range of areas that we practice in. So everything that I have told you about so far, as the different ways you can serve as guardian ad litem, at some point in my practice I have done. So part of getting to know your community would be at the top of the list, and your local judges, and then going and talking to them. So in my rural end of the state, a lot of the counties, they call them part-time public defender positions, but at least one of those positions in almost all the counties is the guardian ad litem position for juvenile court. But they also have part-time public defenders to represent the parents and all the other people. So you end up with sometimes 5 or more attorneys in one case when it's juvenile court. But the way to get on that list would be to talk to your local presiding judge, like whatever county that you're in, that you're interested in serving. I would ask for a moment of their time and go meet with them and let them know that you're interested in serving. The good thing about serving, if you're with the county, is you're guaranteed your payment. So on guardian ad litem appointments, for a while, I quit practicing or quit accepting appointments because the courts, especially in family law, weren't good about seeing that you got paid. So I just started doing that again, probably in the last 5 to 10 years. And this time I got smart about it. So I file up front with what my retainer fee is, hourly rate, get the judge to approve that. They have to pay that up front before I do any investigation. And so that's worked out well on the private end of those cases. Anything in a probate court, you're going to be paid by the estate a lot of times. So you're also fairly confident, that you're going to get paid. Because obviously, you want to do the work, you also want to get paid for it. So that is also an issue that you would want to check on, when you're asking around about different ways to serve. So when I originally started, it was my chief judge in Williamson County that talked to me about it, and then got me on board with doing the GAL position in my county. And like I said, I was able to do that for about 8 years. It really was a great experience. You're in court a lot. However, it's part-time, so you kind of got to keep an eye on that because it kind of overtook my practice. But I'm a solo, so I don't have an associate. So I had to make a choice, and I decided to keep my private practice because I get to do more variety of things with that. We have bar meetings in our local area. Jackson County has them, Williamson County has them, and that's a great way. They're not restricted, so I could go to Jackson County bar meetings and meet people and just ask around. And so to me, a lot of attorneys they're looking for good GALs. And They really, if you do one job and you do it well, you're going to be at the top of their list. And because we are in a rural area, a lot of times the judges is going to take our recommendation or our request. So like a case that I have in probate or adoption, I go in and say, I want so-and-so to serve as the GAL. I've talked to them. They did a conflicts check. They're willing to serve. And the judge will appoint, who I'm asking for. So once you meet other attorneys in your area and can let them know you're interested in that type of work, you'll get appointments, and then it's just a matter of do your job well, and then your name will get out there, and they're all going to be wanting to appoint you. Any of these cases that you wanted to just go sit in court and watch, you could look at the docket and see what's set. Probably any guardianship. Now, disabled adult guardianships, they can ask for them to be confidential, so you'd have to step out. But to be honest, most of the time, no one makes that motion, and it's just open court. Adoption and juvenile court would be closed, so you'd have to get special permission to attend and to sit in to watch those functions. But I've been involved in cases where we have had potential clerks or others ask permission and be allowed to sit in just to kind of get an idea of what goes on in those court functions. But like most family law cases, guardianships of minors, divorce, paternity, all of those type cases, I'm sure are open and you can attend. Now you could attend by Zoom. No one's even going to know. I mean, a lot of the time it's just open. You can click on and kind of watch the proceeding. Okay, so I would concentrate on what areas of practice are interesting to you and which ones you would like to maybe expand your potential in. So, let's see. Let's go back to, if I can get this to work again. Qualifications. So Sarah was asking about the qualifications.
And Andrea, that's not, at least for me, it's not filling the whole screen. So I'm not sure what's happening. Maybe Krista knows, or Samantha. I don't know if anybody else can read that. It's very small.
Oh.
We can see your files.
Okay, well then I don't know what I've got it on my full screen, so let me go back and try.
Do you know, Krista, do you know why it's doing that? I've never seen it do that before.
When you're selecting which screen, there you go.
There we go.
You can
Perfect.
just select that screen instead of just in general.
Right, yeah.
There you go. Now we can see it.
Okay, so this is what Sarah was asking me about earlier. It's actually under the Rule 906. So this rule lays out the qualifications, and I even highlighted it in green. So when you look at this, you could see, and it mimics that application form that I gave you for the 10 hours in the 2 years prior. And I often get things that show, where they're doing trainings specifically geared towards guardian ad litem work. And so you could also just do that training and it's going to qualify you for this type of work.
Yeah, I was going to say, as the other Sarah just said, the ISBA actually has a 10-hour CLE that they update every couple of years. And I'm going to put a link in the chat. It's just a little plug here. As a member of the ISBA, you get 15 hours of free CLE every year. And so you can use that for this. You don't have to pay for it. And it's online, although I think maybe they'll have in-person ones again, but I'll go ahead and put that link just to where the free CLE is on there. And you can see all the different ways that you can get free CLE. And many of these programs are really good. So I'll go ahead and share that with everyone.
Yes, that would be great. And I think that's what I just recently saw. It was an ISBA training.
They're really good. They're good programs.
Yeah. Oh yeah. And it had been posted for, you can use this with your 15-hour free with your membership. So what I was saying about the pro bono representation is actually laid out in this rule in the part that I've highlighted in your attachments. So the thing about that though, I mean, I haven't, it's not an overwhelming, requirement. So it's not like I've gotten too many of those where I would be like, oh, I don't want to be on this list because I'm going to have to do all this pro bono work. So I just wanted to show you that is highlighted in the attachments, and that's in the rule 900, 906. Okay, so let me look. Oh, a new one, which isn't new. I mean, it's been around for a while, but I did find one area that I had never been appointed in, and that was for guardian for persons not in being yet. So I thought, oh, wow, see, now that's something new to me, that I had never had seen anyone appointed, and I myself had never been appointed. And so I sent you guys that as well, just because I found it to be interesting. I was like, oh, well, you could end up serving in a case where the child had not yet been born. So that was just a short highlight. And so if you want to go back through the list with me, and I can cover in more detail.
So the guardian for people not in being, we actually just had a case. I do eminent domain work for the state of Illinois. And so
Really?
we have a case where the last known owner of our piece of real estate was from the 1800s is when he died. So we had to trace his heirship all the way up to the present day, which there's a lot of people, and there were a lot of unknown heirs and legatees. And because of that, the statute, both the eminent domain statute, that statute requires us to appoint a guardian ad litem. So because we have unknown people and we don't know if they are minors or disabled adults, we don't know. So we had a lawyer that we appointed as a guardian ad litem, and basically his job was to just kind of make sure that we were following the proper steps for getting our eminent domain case, and getting what we needed there. So it was interesting. He also had never encountered that. We had done that once before, but that's another circumstance where that could crop up if you have a real estate issue with a title issue, something like that. So
yes,
yeah, not a super common. I don't think it's very common, but it does definitely happen. So there's a lot of ways that it could crop up in, I think, guardian ad litem work in a lot of different areas of practice.
yes. So well, and I've had it come up and it was a double thing because it was probate, but within the probate, we discovered that there was real estate and it was owned by a minor. And sometimes you're like, why do people ever do stuff like this? But he was an older gentleman and he put his daughter's name on it, and she was a minor. So then we ended up with a GAL, not just with the probate estate issues, but also with the real estate and whether or not we should sell it, or, what we should do with it, and what would be best for the minor, in the long run for us to do. So there's a lot of different ways to serve, and a lot of different categories of law that would maybe come up while you're serving as a GAL. Okay, so let's see, do we have any questions? So I guess other than me going through each one of these, that's how I caught the guardian for the person not in being yet, because I had not went through my list. Okay.
So guys, what questions do you have for Andrea? She's told us lots of different information. And I will tell you guys, this is I am in this, I do this area and I love it. It's one of my favorite things to do. I do guardian, Andrea does a lot more than I do, but I do guardian ad litem work for minor children in divorce and family cases and in probate cases for minor guardianships and disabled adult guardianships and adoptions, not the juvenile work, but it's just super, super rewarding and also sometimes heartbreaking and really hard. So you'll have cases where you could see that the child is being used by people a little bit to fight about stuff. And it can be really hard, but you can be the person that is in there kind of trying to help represent that child's interests, or that disabled adult's interest, because it actually happens in those cases as well. So it's a very rewarding area of practice. So, so what questions do you guys have for Andrea?
Yes, because that's all I have in my notes. And then I thought, well, I could go through each section that I had attached for you guys and then see if you had any questions.
If you don't have questions, you're just gonna have to listen to us tell you war stories, which, you know, that's boring. Nobody wants that. So
Yeah, we got plenty of
Sarah
them.
might have some, I don't know.
I actually do have a question. I should maybe know this because I do also serve as a guardian ad litem, but I work at I mean, not a bigger firm, but like a firm. So since you're a solo practitioner, I don't know the business side of this, but I was just wondering if like the ethical rules with IOLTA accounts and all of that also apply to any funds that you would receive through your work as a guardian ad litem, or just looking for any kind of like insight as to how that works.
Okay, so like I said earlier, it's that the initial problem that I had was getting paid in the family law cases, because I mean, think about it. You're going to do an exhaustive investigation. You're obviously going to make someone mad. You know, someone's not going to be completely happy with your recommendations. And so if you wait till the end, you know, they're mad, they're going to try not to pay you. But the trust account doesn't come into play unless you're holding funds for the child or for the disabled. So like for my fees and for the retainer fee, it's other parties that are paying that, you know, on behalf of the child. So I handle that just as I would any other retainer fee.
Okay.
And then I also get court approval for how I'm doing that. That's why I filed the motion, the court order, they're ordered to pay it. I'll put in my orders a lot of times other things that I know that's going to come up, like they have to sign consents for mental health records. They have to provide, you know, educate, you know, all of that kind of stuff, that discovery, you know, information that I can cover in that order, and already put a duty for them to provide those documents, sign any necessary consents, and cooperate fully with me. Throw all that in that initial order. But on the business side of it too, I have been cautious about doing the every 90-day billing. You know, that's in those rules. So I send that out to the attorneys every 90 days. That's how I do my billing system. So on the GAL cases, it'll automatically bill, you know, quarterly basically. And then I'll send that to the attorneys. I don't always file anything with the court. It kind of depends on the case, and you kind of use your own personal judgment on it. Are these people being difficult? Do I want the court to see what I'm doing and how much funds are left? Because sometimes they're just so cantankerous that I file it with the court. You know, I'll file a 90-day status with the court and attach my bill, and then just ask the court to approve the fees to date, even though I still have that retainer fee and I'm billing basically against that retainer fee. But that way too, like I had one I just did where their retainer fee was getting ready to run out. So I thought, I think I'm going to file this one with the judge, just so the judge can take a quick glance at it and we'll know kind of where I'm at as far as how much GAL fee has been used so far. But yeah, like I said earlier, I mean, you want to do the work, but you only want to do the work if you get paid. And so, I mean, I try, and the only reason I got back on the Rule 900, you know, chief judges list was because I thought I had that fight with my local judge about, hey, you can't restrict on adoptions. You know, that's wrong. That's the wrong application of the law. And I convinced him and got him on, you know, doing it the way I wanted it. And same thing with guardianships of minors and disabled adults. You know, I had a judge that was, he appointed me through the whole thing, even though I wasn't on any list, and we had a chief judge saying, you can only appoint people that are on this list to serve in any capacity as GAL. Well, that was a big blanket over the whole thing that was inappropriate. But like one of the associate judges here in my county, he used me quite frequently in probate court, and he just ignored. I mean, that's all I can say.
Yeah.
He just ignored it because he knew that wasn't correct, and he was going to appoint me. And so I got agitated with that part of it. And so I thought, well, I'll get on your list, but then if I don't want to take family law cases as a GAL, I'm just going to say no. But for all those other type cases that I do like serving, and I have numerous ones right now that are disabled adult, guardianships of minors. Right now, I don't have any juvenile court ones because in those cases, I'm normally private pay attorney for one of the other parties or the foster parents. So I'm not serving as the GAL anymore in those type of cases. But I finally just filled out that form and sent it in, and was like, put me back on your silly list, I guess. And so, because in smaller areas like we're in, and like I'm right on the border between the First Circuit and the Second Circuit.
Okay.
So what happened was the Second Circuit basically said, if you're on these lists for the First Circuit, then we're just going to put you on our list. You don't have to fill out nothing or show us nothing. We're just going to have you on the list. And in the Second Circuit, I was still getting, you know, appointments and things. And I thought, well, okay. So I filled out the paperwork, and so now I cover 2 circuits. And then once you're on the list, like the Second Circuit, and Sarah, you might be able to help me with this, is they'll have you send yearly, or maybe even every other year, like a statement that you're in compliance to be able to stay on that list. And some of them require your malpractice insurance, your ARDC card, and that and then you sign a statement that you've complied with the CLE requirements.
Yeah, the First Circuit does that as well. They don't require ARDC card, but they require your malpractice insurance, like your declaration page, and they require. They do have a form where you're supposed to say, I'm doing my 5 years or whatever of renewal CLE, but it's not routinely sent out very well. So that's something that probably needs to be, because, you know, you want people to stay updated because things change, you know, ideas for how children should be parented and whatnot change. So that's why they want you to stay updated.
Right.
Totally.
Right.
Thank you. That was super, super helpful.
Great. Well, I hate to keep saying this, but a lot of times in rural areas, some of those type of, you know, requirements get overlooked. So the chief judge, though, he has a really good secretary right now, at least in the First Circuit, where I am getting regular emails from her. And it's kind of the same requirement for mediators. The same type of list is created for mediators. And then you do the same thing. You supply that you've done domestic violence training and a couple other things. And then they keep you, they keep you on that list every year. They just update it when you give them information to update. Which, preparing for this, funny enough, I hadn't looked at the list in a long time. And so I got the list and was scanning through it, and my hourly rate was like what it was, like 10 years ago, maybe. And I thought, I really need to update that. So I emailed our chief judge's secretary, and she's like, oh, I'll correct that right away and republish. So I
would agree with Andrea too. You know, in rural areas, I think in small towns, one of the benefits of that practice is that you have the ability to, you know, as Andrea suggested, go in and meet with a judge, obviously make an appointment is probably best, and just talk with them about your interests. You know, I really am interested in being appointed in these kinds of cases, et cetera. So it's good because you have that access, which I don't think that you probably have in Cook County, for example. It's a little different,
Mhm.
obviously.
Yeah.
Different, not saying better or different or worse, but just different. But the other thing about it is that that getting on that list also, you know, just because we have that list doesn't mean that the judges will always look at it. So some of the judges, particularly ones that have been practicing for a while, they just get the same people all the time that they know, right? So there's a couple attorneys that have been doing GAL work for a long time. And so they're just always, oh, we'll just pick this person, you know? And sometimes those people actually have more cases than they need, that they can, you know, they kind of were like, stop. But it's because they don't know who you are necessarily, just because you took the ISBA training and you're on the list, or you went out and took the required 10 hours, sort of more a la carte. So doing that, getting into court just on your own cases, then also getting into the court and talking with the judge and expressing an interest, and then always doing things that maintain a positive reputation for you, those things will really help you if you do want to get appointed. You do have to sometimes be a little bit more proactive, I think, if you're a newer attorney. And you know, like you can tell your partners too, I'm interested in this, and have them speak for you too. Go to those bar meetings and talk about it with lawyers, you know. All those kinds of things can really help you if you do want these kinds of appointments. And they're a great learning experience. I think I actually came about it in a weird direction because our firm didn't do family law. Well, we had one attorney that did some family law, but not a whole lot. And I came at it from just getting appointed by a judge in a JL case, just randomly in 2006, before there was a rule. And I had no idea what I was doing, and somehow managed to bumble through it. And I was like, I kind of like this. And I was appointed in a probate case around the same time, which I did know a little bit about. And then they came out with the rule and I got educated and all that. But I actually learned family law through being a JAL, kind of the opposite direction that probably should do it. But that's the way that I did it. Because I figured finally, I really should know more about this underlying area of law if I'm going to be a JAL. So
Yeah.
and now I do almost all GAL work and very little actual like family law representations, except for Land of Lincoln, because I just don't want to.
Right. Yeah. I just realized too, one of your attachments is compensation for the guardian ad litem in estate matters. Cause I was thinking, some of you guys might want to know how to get paid when you do this work. So, and that would be fixed by the court and taxed as cost of the proceedings. And so, like I said earlier, that's one of those circumstances where you know you're going to get paid. And I mean, you want to do the work, but you also want to be paid for it. So I think all of the other, and Rule 907, minimum duties and responsibilities. I thought you might want to take a look at that, because it basically lays out what the responsibilities of the attorneys for the minors are. And one of my pet peeves, I'll just say, in juvenile court is a lot of times the guardian ad litems are not, because there's in the Juvenile Act, there's a list of things that the GAL is supposed to do. And one of them is at least a yearly meeting. Like I said earlier, those cases they'll sometimes last years. And to me, it's important that the GAL actually have some insight into the child's life and living condition. So at a minimum, the 1 year in person meeting with the child, no matter what the age of the child, because if you're having that in-person meeting, you're getting to see the foster parents interact with the child. And so I'm a stickler for that one. I don't think it should be waived. It gets waived way too often. And that's partly because of the overwhelming caseload of that area of the law. But in the cases where I get in and I'm representing someone else's interest, like the foster parent, I require those meetings be done, because usually when the guardian ad litem meets with the child and sees my clients interact with the child, I can get them on board, with whatever it is I'm trying to maneuver in that case, like a change in the goal or whatever. So, anyway, I just wanted to add that was in your attachments as well, that you would maybe want to take a look at. Okay, so any other questions? Anything at all? I'm used to doing substantive, like have the substance of the law. So this one was new, like just how to try to break into this area of practice. But as Sarah and I have been able to show you, there's a lot of different ways to do it, and a lot of different topics, so it certainly doesn't get boring if you get into this
No.
type of work.
It is also an area where you have to, you have to be able to deal with people being unhappy with you. Because usually at the beginning, before you do your report, mostly, although not always, people are really polite to you.
Yeah.
Because they want you to, they want you to be in their favor or whatever, especially in family law cases. But then once you do your report, sometimes someone is unhappy because you may not say that they should have what they want. So, and also, family members sometimes, I don't know about you, Andrea, but I have experienced the angry grandma and grandpa multiple times.
Yeah.
In one of my very first experiences I think it was my second case. Actually, I think it was that first case that I got a very angry call from a grandfather who wasn't happy with what I had done and just completely tried to ring me on the phone. So, including telling me that he hoped I had another practice or another area of career lined up because I wasn't very good at the one that I had chosen. So, so you just, and it's like, okay, well, I can tell you're angry and you're not going to talk to me like that. But yeah, so you do have to be able to realize that it is definitely often a very heavily emotion laden area of practice. And, you're going to have some folks that are very, very happy with you and some that are not. And you just have to not take it personally. So,
Right.
But it's a good learning experience about how to not take things personally.
Well, and ARDC.
And most people are not like that.
Yeah. Which that was one of my first outcomes in a family case. The lady was just really not happy and reported me to the ARDC. And I was like, what?
Oh, yeah, that happened too. Mine was a grandma.
Oh, well, and so the ARDC just wrote me and was like, well, just for your information, she reported you and we're not even gonna open the case and we're not even gonna ask you to respond to this, but we wanted you aware that she had done this. And so guess what? Next time I went to court, I went marching up to Judge Wilson and I was like, I need to make the court aware. She turned me into the ARDC, like I had already made my opinion. I'd already filed my report. So the fact that she did this, and I can't say how mad I was over that on this, but I was very upset over it. I was like, but it's not going to impact my decision because I already made my decision and it was already filed in this case. But full disclosure, I let the judge know what had happened. So anyway, it's very rewarding though. And you got to keep in mind in these type of cases, usually there's two other attorneys, almost always maneuvering, filing, doing different things. And you're Switzerland basically in the case, and your only client is either the child or the disabled adult. And you remain calm and neutral and just trying, it's always best interest. Always, always is what you're looking for in these cases and what you're fighting for. So if that interests you, trying to help someone weaker and not well represented in the law and not going to get what's, coming to them or, unless someone gets in there and fights for them, then this would be your thing. This would be something you would enjoy doing. And as an example, I'm in one right now where it's a disabled adult one. And I have, 2 adult children fighting with their mother, and so she tried to get the upper hand and she filed, which that doesn't happen very often. You actually have the alleged disabled person file on their own behalf to have someone else other than her children appointed. So it's been an interesting one. It's still ongoing, but you get that little taste of, I can help this person. I can help them overcome all of this that's going on and do what's best for them. And
sometimes one other thing that happens is that you actually help settle the case, because I actually have had multiple examples of this, but sometimes the lawyers are so busy that they really haven't sat down and talked with their clients that much. They really haven't sat down and talked with the other side, and you get involved. And I mean, I had one where we basically at the end of it, and you have to be really careful about this because you have to be clear, you're not a mediator, which is a totally different role, but you can have a conversation with everyone's permission with the parties and sometimes get them in the same room, and you're, you know, as long as you're make it clear that it's not a confidential meeting, you know, because you have a duty to report to the court. If something comes up, you may have to tell the court, but you make it very clear to them. But sometimes they just need someone to help them sit down with them and talk. And for whatever reason, the mediation thing didn't work. In the case I'm thinking of, actually, I had spent several months with these people because of the pandemic and things got all drawn out. And, you know, I tried to get them to go back to mediation, which they hadn't had a positive experience with. And they were like, we just want to work with you because we've gotten to know you. And so I did, with a lot of disclosures, and they were able to just sit down, and mostly they did almost all the talking on Zoom, but they were able to work out a lot of issues that they really had been struggling with. So, you know, and sometimes just your report itself, you'll put your report on file, and the attorneys will look at it and be like, oh, this makes sense. I mean, I had one where they were fighting over 50-50 parenting time, which oftentimes I think is a terrible idea. But in this case, it was a great idea. I actually recommended it. And after everybody read it and understood why, they all thought, this, you know, let's just do this. And they did, and it worked out okay. So just, you know, that's another really positive thing, is you can actually help folks resolve their problems.
Right. Yeah, and the written reports, most of the cases you end up doing written reports, but not always. Like guardianships for the minor child, sometimes those are uncontested. You just meet with the child or go see the house or whatever you think is necessary. You don't necessarily have to do a written report. You'll just show up and verbally report. And again, that's up to your local judge and the customs. And so that's who you would want to talk to. And so like we recently had a judge change here in the county. And a lot of times I'll just go to that judge that's assigned to the docket and be like, hey, how do you want this? Do you want a written report? Is my verbal report at the final hearing good? And then like Sarah said, though, if there's issues that you want to be sure that the opposing counsel addresses, or something that you know is a red flag, I do a written report and I put it all out there, and then they'll either settle, you know, or figure out a way to address that because they don't want to leave it up to the judge, you know.
Yeah,
so
which is a good, it is a good, even if you're not a GAL, if you're going to represent clients, which I assume most of you already are doing, just talk with your client, listen to what they're saying, and make sure you understand. And also look at the paperwork, look at whatever the documentation is, because sometimes your client isn't right. Sometimes your client isn't telling the truth. And sometimes it's just your client's version of events, and the other side may have a different perspective. So, but I've had many attorneys where I've had conversations with folks and put things in my report, and the attorneys were like, what? Like, they had no idea that their client had some information or, you know, said something or whatever. So, you know, as the lawyer in cases, you know, it helps you to realize like, oh, I really need to be listening to what my client is saying and making sure I know what's going on in the case. And sometimes that's hard when you have a lot of cases, but it really is important, because otherwise the GAL may know more than you about your case.
yeah, yeah. The example that I was just talking about, my report was like 23 pages long. I mean, I interviewed everyone under the sun, the accountant, the trust attorney, you know, and I just put it all out there. And so, yeah, the other attorney called and said, so I've lost my case, but, and that was just from my report. I mean, they still have to prove their case, you know, in court, because I'm not calling all those people as witnesses, but the judge read my report, you know, and so there you have it. It's a weird way that a lot of hearsay, I mean, really, right, Sarah? A lot of that kind of stuff comes in.
Yeah.
And the court's relying on your veracity and, you know, your reputation, basically, that all of that took place, and that's what they reported to you.
Which is why it is a little stressful. You have to be very careful. Like when I do a report, I am very careful. I try very hard to not like paraphrase something that someone has said in a way that implies something that maybe they didn't say. Like, especially if it's something like very specific, I may actually write the quote down and quote them, as opposed to me putting it in my own language. You know, you really want to think about that. And also remember too, if you do this, that I always end up having, you have to talk to one side first, right? So I always talk to the first side and I'm like, this case sounds really strong from their perspective. And then I listen to the second side, I'm like, oh, this sounds strong too. So you always have to remember that, right? And I would say most of the time, there's not a lot of nasty and nefariousness of like really bad nature in these cases. A lot of times they get to the GAL just because they can't talk to each other, they've never talked to each other, whatever. There are some that there is some really bad stuff happening and you do discover it, but mostly it's just people that they don't like each other, they're not listening to each other. Maybe they, for whatever reason, the mediation didn't work out. But you definitely have to be careful what you put in your report. Like over time, I've actually put less stuff in my report, just really thinking about what is important to put in here, because you're probably also going to have to testify, and and then you can explain a little bit more about what it might mean in your report.
Which I should have put that on my list, and my apologies for that. But I have been called and required to testify, but only very rarely. To be honest about it, they get your report, and like Sarah said, a lot of times they'll settle because you could the handwriting's on the wall, so to speak. And
you might get deposed, you might have to testify, but you're right. It's for me, it's not the bulk of the cases by any means.
No. And the last one that I had to testify in was a disabled adult case. And they were unhappy because I kept requiring basically that they maintain my client, because really the ward is my client, in a locked facility. And that was based on some mental health issues and basically the requirement of the treating physician. So I didn't mention that either, but in disabled adult cases, you're also going to have a physician's report that you can rely on and look into what the findings or diagnosis are. But don't let that scare you off about having to testify, because it honestly, it rarely comes up, at least in the First and Second Circuit. I think I've been called 2 or 3 times, and I've been doing it for a very, very long time. And really, that disabled adult case I was just telling you about, I was the only witness. They put me on the stand. I testified for like 2 hours. It was crazy, because then I turned to the judge and I said, I am not a mental health expert. I'm not a psychiatrist. I have an expert's opinion written in this physician's report, and I'm bound by it. I can't get around that. With some clerk at a assisted living place that said, oh, she could live there. I'm like, I'm sorry. I would like for this to happen, but I can't agree to it. And in the end, when he did his ruling, he repeated exactly what I said. I'm not an expert. I have an expert's opinion, and I have to rely on that. So anyway, okay. Did we cover our time?
Yes.
Yay. Thank you all for paying attention and asking questions. And I hope the materials help you out some too. And take your business cards with you, go to bar meetings, go meet people, go meet judges, leave them with your card and your willingness to work. And you'll get this type of work if you want it.
Thank you, Andrea. Thanks for your time.
You're
so
welcome.
much, Andrea. Thank you guys for coming. Have a great day.
Yes, happy Valentine's Day.
Thanks.